Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. What does a parent have to do to regain lost custody? So let's deal with this scenario. Two people have a child as a result of a marital or non-marital union. For the purposes of this discussion, I don't think it really matters. Point is, they have a child, they had a relationship, they had this, they had that, and eventually the relationship breaks up, and now we have to figure out who's going to get the custody. Where's the child going to live? So we file competing petitions, the court entertains all the motions, all the oral argument, the court conducts an evidentiary hearing, it hears from this witness and that witness, and looks at this exhibit and that, and comes up with an answer that dad will get the physical custody of the child. The question is, can mom regain that custody? Well, you have to understand one thing. The court has a very strong interest in finality, meaning that the court makes rulings in order to resolve things so that people can move on with their lives. So just because you lost doesn't mean that there will be an opportunity for you to regain custody. The court will allow someone to regain custody, but it'll only be if the court feels that no longer is the best interest of the child being served by the existing custodial arrangement. Therefore, we got to switch it. In order to bring that to the court's attention, you might file a motion and you might tell the court, look, 3 years ago you gave custody to husband. Now I want custody, but it can't be because it's my turn. There is no turn. What it has to be is, I want to regain custody because it is no longer servicing the best interests of my child. The circumstances have changed. The custody is no longer stable. The child's flunking out of school. Dad is going to prison for some reason, and therefore there's not going to be anybody there. There has to be some compelling reason to tell the court why it should even revisit the issue of custody before even deciding whether or not it should be changed. So can you regain custody? Yes, but number one, you're going to need to show the court that there's some change in circumstances that would compel the court to look at the custody issue again. It can't be because you feel it's your turn now. That won't be a circumstance. When the court gives that custody order, it well realizes that this is going to go until the child is the age of majority and ages out. And therefore, the fact that years are going to go by is well in the contemplation of the court when it signs its original order of custody. That's not going to cut it. You're going to have to show that something is going on now that the court did not contemplate. The court did not contemplate that the custodial parent would become irresponsible, that the custodial parent would become a drug addict or an alcoholic. Court did not contemplate that this person is going to commit a crime, he's going to go to prison for 5 years. These are reasons why the court might say, wait a minute, I know we gave custody a couple years back, got to change it now, or at least consider changing it now, because the thing that I relied upon, the circumstances that were in place then, no longer in place anymore. And if the court feels that there's been a significant change in circumstances, then it will conduct a hearing and it may well cause the other person to regain custody. But again, it won't be because we're switching off. It'll be because the court feels that the best interests of the minor child are served by a modification of the custody order. If you have any questions about your case, reach out and we'll be glad to help you out.